Imagine this scenario. What if you could go to a sentencing hearing or hearing to try to keep your professional license with all of the inside information you need to put yourself in the best possible position to succeed? Does that sound like something that would interest you? If it does, please watch this video because I'm going to give you this inside information that I'm going to channel in part through a federal judge who was interviewed by my business partner, Michael Santos. So I'm going to put up a 2.5-minute clip to that video with the judge at the end of this video. What I'll cover in this video today is not just the importance of character reference letters, but some common mistakes that people make. After all, it does no good to go through an extensive mitigation strategy, in some cases over a period of months and years, to then have one word, one statement, one line derail all the progress you've made. And that absolutely can happen. We're dealing with cynical stakeholders here, a probation officer, a prosecutor, a judge. You need the right content at the right time to influence these people favorably. So you've got to invest the time. You have to do the work. So about 6 weeks ago, I sent an email to our list highlighting a defendant who called after sentencing to tell me that his judge had filleted him and his lawyer by essentially turning in letters that looked boilerplate. Further, he admonished the lawyer and asked the lawyer, "Did you even read these? I'm not so sure you did." So all of the other good stuff this defendant had done worked against him because the judge spoke at length about the mistakes in these character letters. So let's jump right in with some common mistakes to ensure that you don't make them. Well, in the sentencing world, one common mistake is the writer writing that it wasn't the defendant's fault. And you may be thinking, well, I didn't have bad intent and I want the judge to learn more about the circumstances through the person writing the letter. That is not the intent of the letter. And at the end of this video, I'm going to close with 3 very easy to follow takeaways to help make your letter great. And I'm going to read an excerpt from a letter that I turned in at my sentencing that Judge Wilson discussed and referenced. You cannot in the criminal justice world have your cake and eat it too. In other words, you can't plead guilty and then say, well, I didn't really do it or I didn't mean to do it. It may be true. It's not the right message at the right time. So too many letters in our experience, character reference letters, convey, if not directly, it wasn't the person's fault, they insinuate in a matter-of-fact sort of way. And that can be very off-putting to a judge. And if you have a lawyer that's not dissecting and reviewing every single letter and editing and removing, you're going to have a problem. So that's the biggest mistake that I see again and again and again, people writing that it wasn't the defendant's fault. The second mistake I frequently see is that the government or jury kind of got it wrong. And again, kind of aligns with the first fact. The government overcharged. The government sends too many people to prison. This is not a good use of our tax dollars. This is a first-time nonviolent offender, or there are no victims. There's no financial loss, as was the case in the Varsity Blues case, for example. May be true, technically no victims, no financial loss, but is that the right message in a character reference letter for a judge who's deciding how long your contact, your supporter, or the people with whom are writing letters for you, how long you should serve in prison? So it is a common mistake stating the government or jury got it wrong. If you're going to have someone write that sort of letter, don't have them write a letter. Just don't turn it in. If they write it, thank them. It shouldn't be turned in. Okay, I just see it too frequently. Another problem and a common mistake in character reference letters, and you're going to hear Judge Bennett discuss this at the end of the video, is someone writing a letter then telling the judge the defendant shouldn't go to prison. And it's just terrible, right? This is a federal judge appointed by a sitting president who has a great deal of power and responsibility. I can assure you, as Judge Bennett will discuss at the end of this video on character reference letters, I can assure you the judge does not want to be told what the sentence should be or that you shouldn't be going to prison. It's obvious you don't want to go to prison. It's obvious your support network doesn't want you to go to prison. Do not make that mistake of telling the judge the defendant shouldn't go to prison. When you do that, you're essentially trying to do their job for them. It goes poorly. Another common mistake, and a lot of, when a defendant gets in, my lawyers did this. Defendant gets in trouble, the lawyer says, collect letters, here's a template, here's a form letter, here's something to follow. Well, if the proper amount of time is invested in getting great letters, and I'll put up a URL here to characterletters.com. It's a free course our team teaches where I walk you through my letters, why they were helpful, what judges tell us. So you can have access to all of these letters and learn the makings of a great letter. So I encourage you to go to characterletters.com. .com, but when you read the letters that were turned in on my behalf, you will learn not one of them was templated. Not one of them looked like the same person wrote them. It was in the voice of the person writing it. Now, I may have had some suggestions. I think it's good to give guidance like don't tell the judge what to do. Don't say that it wasn't my fault. Don't say that I shouldn't go to prison. Common mistakes I just addressed. Do not follow a template. Judges see through it. It's lazy. It's boilerplate. And again, it can derail all of the good work and mitigation that's been built up. So I am concerned sometimes when a lawyer sends a template to their client that says, here's the guidance and templates on how to get letters. I think it's lazy and it lacks, it's not specific. It's not extraordinary, turning in templated garbage stuff. A couple of other things, and then I'm going to turn it over to the video with Judge Bennett, then I'll read my letter. A letter that isn't addressed to the judge. So I have seen defendants compile letters. It says, to whom it may concern. It doesn't address the remorse, the shame, the conduct, the crime. And it's clear someone was asked to write a letter without knowing that, hey, I'm going in front of a sentencing judge trying to avoid prison, or I'm going in front of a board to try to keep my real estate or law license. Our team is working with someone now who was a civil issue, not criminal, trying to keep the law license, going in front of the board to try to keep the license. To be clear, it's going to be addressed specifically to the board. In my case, I tried to keep my real estate license when I came home from prison. The new letters that I collected were written specifically to the California Department of Real Estate, the commission who was evaluating my fitness to keep my license based on my conviction as a securities broker. So if you have something that is addressed to whom it may concern, judges are going to go through it. Don't turn them in. I beg you. The last thing I'll convey for common mistakes is too many letters. So our team speaks at length about the right conduct at the right time. You will give specific conduct to a probation officer. That may differ to the judge. That may differ to a case manager in prison and a probation officer when you come home. Content is key, but it's got to be the right content at the right time. Too many letters can work against you if your judge favors brevity. In my case, I compiled 16 letters. I only turned in 6. Judge Wilson commented on all 6 letters. I don't know if he'd have read 16, but I also know that he favored brevity. So a common mistake is compiling 40 or 50 letters. In time, they begin to get a little watered down, and you're running the risk the judge may not read them all, especially if they all sort of say the same thing. A caveat to that, of course, is some judges will read a great deal of letters. We've had clients, for example, go in front of Judge Hall, a judge in Connecticut, who I believe has commented that she's open to reading as many letters as will come in. I think that's an anomaly. I think judges favor brevity. So it's okay to compile 10, 20, 30 letters or 40 letters. I'm not telling you to get 6 letters. In time, you will use them at different stages of the journey. You just don't get content, use it, put it in the shelf, and throw it away. Here we go. Here's the shameless plug for Lessons from Prison. No good if this sits in my garage, or I'm not going to my Amazon page and selling it to universities or giving it to you for free. It does no good. You use it for the rest of your life. So you may get 30, 40, 50 letters. You may only turn in 10, and that's okay. So before I turn it over to Judge Bennett with Michael Santos, I'm going to wrap up the makings of what a very good letter is and then read a snippet from my letters. It's very simple. Your letter should show the positive contributions you've made to society. Pretty simple. A specific story or detail about your life, your character. I don't care who it's from. Gardener, your dentist, your friend, your plumber, street sweeper, as Judge Bennett said. It's not a matter of who's important or high profile or celebrity. It doesn't matter. Can they speak to your character? Additionally, the letter should discuss candor about your crime and what you're doing to make things right. That's a community service component of measurably giving back to the lives of other people, which helps them and helps you. And I guess lastly, the great component of a good letter is that you have evidence that you identify with the people that you've hurt, your victims. If that information can make its way into a letter and show your character and your commitment to reforming yourself, you're measurably ahead. That's mitigation. That is mitigation at the right time with the right audience, your federal judge. So to give you an example of something that really helped me at my sentencing hearing was a letter written on my behalf by who was my dentist. He still is my dentist, a very good friend. I was a real estate agent before I went to prison. As many of you know, I sold real estate at Sotheby's for 3 years before I went away. And it was a good time. Made a lot of money, really enjoyed it. I like selling real estate. And in this letter, my client, real estate client, wrote how I did something that helped him. He wrote, Legal representation has been financially draining for Justin, and one would think that he would take advantage of any professional opportunity to alleviate his financial stress. That has not been the case. Early in our relationship, I asked Justin to represent myself and my wife in the sale of our house and the purchase of a new property. Justin would have realized $75,000 in commissions, a lot of money at any time. Certainly in 2007 when I needed to pay the lawyers and come up with money for restitution. Certainly he needed the money. Instead, he advised me to wait a year until I turned 55 so that I might benefit from certain tax advantages. Judge Wilson spoke that I had reformed myself, that I was making better decisions, that I was doing what I was supposed to do, making good decisions on behalf of my clients. I shouldn't be lauded or applauded for doing the right thing, which I did, but it spoke to my character and that I was changing. That was more impactful than a letter from my mom or my dad. Letters, frankly, I did not even turn in because you know what my parents are going to say. Learn from people who have made bad mistakes. Profit from their experience. Compile best-in-class character reference letters and avoid these mistakes. And with that said, I'm now going to turn it over to this video with Michael Santos and Judge Bennett. Again, go to characterletters.com, enroll in that course on how to compile best-in-class character reference letters. And of course, if you have questions for our team while you're on the White Collar Advice site, schedule a call and we'll get in touch with you. Thank you so much for watching this video. And by the way, we went over 6,000 subscribers on the channel. Thank you very much for subscribing and for being a part of our family. I hope you feel comfortable here and find a lot of value continuing to come back. Goodbye.
What level of influence do those character reference have at the sentencing hearing?
I estimated not too long ago, just a rough calculation, that I've read somewhere between 30,000 and 40,000 character letters on behalf of defendants, because it's not unusual to have 7, 8, or 9 in a case. I had a case last year where I had 93. That was a little bit too much. And they all look the same because I found out after questioning the defense lawyers, and they were very honest in responding, that the wife of the defendant had sent out a form letter to all these people, and it had some phrases in it, and the letters just adopted the phrases. So I didn't give much weight to those letters, but I give a lot of weight to letters if it's somebody the person actually knows and how long and how well they know them. So I'd much rather have a letter from a street sweeper or a janitor that has known the individual for, maybe more than 10 years or maybe most of their life, than a letter from a state senator or a United States senator that's clearly writing it as a favor to the family and may or may not even know the individual. So the status of the person writing the letter has very little bearing on me. But it's what they have to say and how they came about acquiring the information that is helpful to me. And I get offended when they tell me what the sentence should be. So a lot of times, please give the person probation. Well, maybe they're an armed career criminal and they're looking at a potential life sentence. Gee whiz, they're not going to get probation. And maybe I'm just idiosyncratic, but I bristle when people tell me what I should do. Tell me how you know the person, what their characteristics are, and then let me decide how that fits into an appropriate sentence. Your job isn't to tell a judge what an appropriate sentence should be. And so give me the facts, how you know the person, why you know them, what their good qualities are, what you think their prospects are for rehabilitation, anything that you think would be helpful. But stay away from actually telling me what a sentence ought to be, because you're not in a position to know that. So that's kind of how I look at it. And I think most of my colleagues look at it in a very similar fashion.